I'm speaking in support of new clause 72 in my name, which tends to put a duty on employers to investigate whistleblowing concerns, to establish internal channels for reporting and managing whistleblower disclosures. In recent years, we've seen scandals rock the country where whistleblowers raise the alarm early on, only for their warnings to be ignored and disastrous consequences to follow as a result. Scandals with thousands of victims, such as the Post Office Horizon, Grenfell Tower fire tragedy and the collapse of Carillion, saw whistleblowers raise alarms only to face a wall of silence. We saw the very worst of this at Yorkshire Cricket Club in my constituency, where Azim Rafiq suffered years of racist harassment and abuse. Yet despite the number of players who admitted to racist remarks or actions, Yorkshire Cricket Club's leadership refused to accept its mistakes and refused to release the full report, only releasing an edited summary. It was only by Azim going in front of the DCMS Select Committee the full scale of institutional racism at the club became known. These failures have a tragic human cost. Never placed significant strain on the taxpayer, and the cost of whistleblowing report has found the avoidable costs incurred due to failure to listen to whistleblowers in the Post Office, Carillion and Letley cases, 426 million. It's unacceptable for the taxpayer to bear the burden of failed systems and a failed legislative framework. It is for this reason why we need a new legal duty for employers to investigate whistleblowing. This new clause would ensure the employers must take reasonable steps to investigate any protected disclosure made to them. This new clause would compel large employers to establish internal channels and appropriate procedures for reporting. By ensuring disclosure and investigation, we prevent scandals such as Horizon from occurring and ensure the harm in the workplace is dealt with early on. This new clause is proudly pro-worker and pro-business, tackling one of the long-standing issues of our current whistleblowing legal framework for workers. The status quo only provides an after-the-event remedy for whistleblowers. This new clause ensures there are chance whistleblowers from the start. EU government protects research found that 76% of workers want a legal duty on employers to investigate whistleblowing concerns. This new clause delivers on these long-standing demands from workers. In light of recent scandals, businesses are realising the value of whistleblowers to help root out wrongdoing and harm within their own companies. The IOD recommend that all employers should be required to meet the standards of whistleblowing and follow recognised procedures in their report on the Post Office scandal. This new clause requires employers to take reasonable steps, meaning vexatious or insignificant concerns don't always require an investigation. This is a once-in-a-generation opportunity to revolutionise the whistleblowing law. The Public Interest Disclosure Act of 1998 was groundbreaking for its time, but since then the UK has fallen behind our comparative jurisdictions, such as the EU and Japan, on whistleblower protections. I hope the government considers supporting this new clause or equivalent measures, which is good for workers, businesses and taxpayers. I hope the Minister will meet with me about this matter following today's debate. Through this new clause, we can take action to ensure that whistleblowers are supported, that businesses are given the tools to root out wrongdoing, and that taxpayers are spared from bailing out state scandals. Thank you.